it cannot be changed. It's like a irrevocable contract. If it's accepted by all parties, everybody must adhere to what they must do. Unless the bond has not been approved, the suspensive conditions are in there. Yeah, so that is why it is very, very important to complete it and not leave any blank spaces in an agreement of sale, please, guys. That is very important. You can rather put in not applicable or refer to something, but you must complete all the empty spaces in a contract, because empty spaces in a contract can just cause you a very big harm at the end of the day. All right. Please stop me. If you want to ask something, you are most welcome to stop me. Once the offer to purchase document has been finalized, the duly completed and signed offer to purchase is presented to the seller for consideration and signing. The estate agent should encourage the seller to read the offer and must explain the meaning and consequences of the material terms to the seller. The agent must ensure that all regulations, policies and procedures have been complied with. And that is so important, especially nowadays with COVID, where we intend emailing the contract to the seller. You know, it's always better to email it to him and do a Teams meeting, put the contract on the screen and explain the contract. I know most of our estate agencies do have a clause at the back of your contract to say that you have explained the contract to the client. If you are not explaining the contract to the client, it is a loophole for him to get out at the end of the day to say that he did not understand what he was signing or something like that. So it's so important to explain it to him, and it is very much easy. I think if you negotiate a lower price, it's a bit difficult to do it online, but if it's close to your price, it's very easy and simple to do an online explanation on the contract. And while you're asking him, must print it out, while you explain to him, he can sign it, he can put it for you immediately back on to the you can even take photos. You can take that photos and combine with Adobe. So it's very simple and easy. We did receive information that apparently they will accept electronic signatures. I don't want to go into deep about it because we haven't received an official document from that. And you know, there's always the laws, everything. So I still think it's a bit risky. If a contract has been signed electronically, next to that electronic signature, you will need a witness signature as well. It's not only the seller or the purchaser that can sign there. Then there's an extra witness, and that witness is to witness the electronic signature. So that's apart from your witness signing at the back. If the seller is a natural person, married in community of property, his or her spouse must indicate consent in writing on the agreement. The spouse's signature must be attested by 2 competent witnesses. Should the seller not accept the offer exactly as it stands, he or she is entitled to make amendments to the offer. This amount to a counter offer. Now, when an offer is a counter offer, it is always advisable that when they sign on the counter, that put a date there as well, because the last signature will then be the effective cause of the sale. If the seller decides to accept the offer exactly as it stands, the seller must sign in full in the allocated space and initial all delections, changes at the bottom of every page, indicating that only initial pages form part of the agreement. If there is an addendum attached to the offer to purchase, the seller must sign it in full. Once the offer has been accepted in writing, a legally binding and enforceable agreement of sale comes into being. If there are any suspensive conditions attached to the offer that was accepted by the seller, the agreement only becomes binding and enforceable once the suspensive conditions have been met. Example, the mortgage loan has been approved. The accepted agreement for sale must now be brought to the attention of the buyer as soon as possible, as the acceptance only legally becomes binding once the buyer has been informed thereof. Any questions? Amendments and counter offers. Once both parties have signed the agreement of sale, it cannot be changed or amended verbally. Amendments can, however, be made to the original documents by means of an addendum. This addendum must refer to the agreement of sale and must be signed in full by both parties. Like, for instance, in your original, or in the agreement, you did say that occupation date is on date of transfer. But now, at close to transfer, the purchaser wants to move in and the seller agrees to that. And then you will put an addendum referring back to your original clause in the contract and say that this clause will now, there will be occupation. And also always remember, occupation, you must, in the original docket contract, put in an amount of the occupational rent for vice versa, because then it means that if it happens that the purchaser does move in prior date of transfer, he will pay that occupation. And if something happens and there's a delay, at least the seller will not be in trouble. Make sure that that payment is a little more, at least, than what the bond is, including the rates and taxes, etc. So that is something that you have to make sure, please. In the event that the seller makes a counter offer, as referred to earlier, he wants to change something, for example, the offer's price or occupation date, it can be done, but not without risks. A counter offer where the seller has deleted the offered price, written in what he is willing to accept, and initials the changes, it is an outright rejection of the buyer's offer, which amounts to the termination of the offer. So if the purchaser then does not accept those changes, that offer becomes null and void. Contractual capacity. The parties to a contract must have the necessary capacity to enter into the contract. We have dealt with natural persons, example, minors and married persons, and their contractual capacity earlier. We are now going to discuss the capacity of private companies, closed corporations, trusts, and individuals acting in a partnership and jointly as joint owners. Companies and closed corporations. Companies and closed corporations are known as juristic persons and are entities that exist separately from their shareholders in the case of a company, or members in the case of a well, we just talk about companies. It is important to note that at least 75% of the members' interest, or 75% of the company's shares, must be held by members, shareholders resident in South Africa, before a property can be registered in the name of a company. When selling a property to a company, it is important to obtain a copy of the respective registration documents. A company is registered in terms of a certificate of incorporation and in terms of its founding statement. The sale agreement will not be valid unless the person signing on behalf of the juristic person is properly authorized to do so on behalf of the company. And you know what, if it's only one director in this company, that director must give himself write a resolution to say that he is authorized to sign on behalf of this company. It is advisable to obtain a copy of the resolution containing such an authorization and to annex it to the contract. The name of the company or CC must be cited in the contract, and the authorized person signing on behalf of the company or CC must enter into the contract on behalf of the entity. It must be stated clearly that he or she is signing for and on behalf of the company, and that he is party to that contract. Trust. A trust is not a legal entity, and as such, it has no contractual capacity. Its trustees can either enter into a contract only on behalf of the trust, and the trustees must be authorized in the trust deed to enter into agreements on behalf of the trust. All trustees must be authorized to act as trustees by the Master of the High Court. Any agreement entered into by a trustee who has not been authorized is null and void. It is therefore impossible to enter into a contract on behalf of a trust that has not yet been formed. Immovable property bought by a trust is registered in the names of the trustees in their capacities as such, and all the trustees must sign the agreement of sale, or one trustee can be authorized in writing by all the other trustees if the trust deed allows it. A partnership is not a legal person, and the names of the partners must be recorded in the deed of sale. All the partners must sign the agreement, or a partner or third person can be authorized by the partners to sign on their behalf. If they do that, then they must have what they call it a resolution, that all the parties must sign on the resolution to give this specific one partner the authorization to sign on everybody's behalf. In the contract deals with a matter that falls within the scope of partnerships business, however, each partner has the authority to conclude contracts on behalf of the partnership. If a contract involves the buying or selling of immovable property and the partnership does not normally deal in property, the authority to sign on behalf of the partnership must be in writing. While a partnership exists, the partners are jointly liable for partnership debts, but on dissolution, the partners are jointly and severely liable. Joint owners. When people buy or sell property jointly, each party's name must be recorded in the contract, and there must be a clause in the contract stating that they are acting as joint purchasers or sellers. Each party must sign the contract, and each joint debtor is liable for payment of his or her portion of the purchase price, and each joint creditor is entitled to his or her pro rata portion of the selling price. If the parties are jointly and severely liable, each joint debtor can be sued for his or her pro rata portion or for the whole amount. I can just mention, when it comes to a company or where there's a resolution, then that company must have a meeting first where all the partners agree or disagree on the specific sale, and then the one partner can sign. So it's not a matter of this one partner now has a free open board where they can just decide to sign and purchase or sell properties on behalf of the company or on partnership. Any questions? Letting and hiring properties. Letting is a residential property, takes hard work, dedication, and specific knowledge. This section will give learner estate agents an insight into the actual price of letting and all the aspects that it entails from the first meeting with a potential property lease, tenant or person who is renting property, until the lease has been successfully concluded with the lessor, landlord, or owner of the property. Discrimination on the grounds of race, gender, marital status, age, disability, and religion is prohibited in terms of the Rental Housing Act 50 of 1999 that came into operation on 1 August 2000. Once the estate agent has selected a suitable tenant for a particular building or property, the prospective tenant makes an offer to hire the premises. This offer is directed at the property owner, lessor, landlord. It is good business practice for this offer to be in writing. It must then be accepted by the lessor in writing. In terms of the Rental Housing Act, a lessor must provide the agreement in writing if the lessee requests it. Although we all sign mandates with this landlords, it is always good when you found a tenant. I know our agents sometimes do not do it, but you know what? If there is a problem in future when a tenant doesn't pay and eviction, etc., then if the landlord did not approve that tenant, you can, although they cannot keep you liable because in your mandate it says that they cannot keep you liable, but it can cause a very negative impact if the landlord say that, you know what, he wouldn't approve the tenant because of whatever reason it might be. So it's always good. What I do is I discuss the rental application with all the documents and the TPN report with the landlord. And then if he say it's fine, let he just send you an email, say, no, he's very happy with it. And then you've got it in writing, then you're covered or 100% covered. The estate agent is responsible to see that all legal and statutory requirements are complied with and therefore needs to know the Rental Housing Act. The Rental Housing Act, under the Rental Housing Act, a written lease agreement pertaining to a residential property must contain at least the following details: the names and addresses of the lessor and lessee, the description of the leased premises, the amount of rental and escalation, if any, payment frequently, monthly or weekly, the deposit amount, if any other charges payable by the lessee in addition to the rental, the lease period, or if there is no agreed period, the notice period for termination, the lessor and lessee's obligations. And another thing that I will add on here, it's definitely interest. That deposit interest is very important to say, does it really gain interest, yes or no? A list of defects must be attached to the lease as well as a copy of any house rules that may apply in a sectional title or group housing complex. That list of defects is crucial because if that list of defects is not there, then the tenant will be liable for any damages that can be in there. What I normally do is I'm doing a full inspection with the tenant in the property. Then I'll still give him an empty list, default list form, and ask them to send it within 7 days to us. If they do not complain about anything else within that 7 days, they will take full responsibility for any damages that can be there. Okay, there is a duty not to discriminate unfair against any tenant in advertising a property to let, negotiating or a lease, and behavior during a lease, including a tenant or visitors or members of his or her household. Unfair discrimination includes the grounds of gender, pregnancy, marital status, sexual orientation, ethical or social origin, color, age, disability, religion, conscience, belief, culture, and language. The tenant's right to privacy must be maintained, including the tenant's visitors or members of his or her household. And I can just mention here that with the new POPI Act, this information for the tenants must always be locked up and closed. It must not, if you received a rental application or even a sale agreement, it doesn't matter, any document where anybody's private details are on, you are not allowed to leave it on a table or a desk. It must be locked up in a cupboard. The landlord has the right to receive prompt and regular payments and can recover unpaid rental on obtaining a ruling by the Rental Housing Tribunal or a court order. Complaints of unfair practices may be submitted to the tribunal. These would relate to the changing of locks, deposits, damage to property, eviction, house rules, intimidation, issuing of receipts, nonsense, overcrowding and health matters, maintenance, reconstruction and refurbishment, demolition and conversions to structures. Any questions?
Hi, Rina.
Hello, yes, Joseph.
Okay, so mine is not really a question. It's just the emphasis on the non-discrimination in terms of the Rental Housing Act. I just wanted to obviously, request attendees to also go look at Regulation 2.6 of the Code of Conduct for Estate Agents. And it's always a question in the PDE exam to say if the landlord tells you or gives you a mandate that I don't want certain tenants to come and stay in my property, what would you do? I just wanted to actually bring that to their attention because it's very important that when they are obviously attending these lessons, then they also know what lies ahead and what other pieces of legislation are reinforcing the Rental Housing Act. I just thought that is important for them to just take note of, but thank you so much.
Yes, Joseph, thank you, and thank you for bringing that one up. I really appreciate that. I know, and I think our biggest challenge as estate agents, when a landlord tells you, I don't want Nigerian people in my flat. Unfortunately, I'm sorry that I mention it directly like this, especially in our area. I think that is very area bounded, as you get the good ones and then you get the ones that is causing trouble. And that is definitely a challenge that we have. But luckily, as you mentioned, in all our rental applications, that thing of the race thing, we took it out. It's not in there. But the reason why the banks can ask those information is only for statistics, not for discrimination. I just want to mention that because I've taken that up with a bond originator and the bank manager, and he told me no, they only use it for statistic purpose. That's all they use it for. But thank you for bringing that up. I really appreciate that. Does anybody want to add on to this?
Hi, Rina.
Yes.
It's Tulani here. I just wanted to confirm about the tenant's deposit and the interest. I believe it's dealt by this Rental Housing Act as well.
It's dealt by the Rental Housing Act and also in our Code of Conduct.
Yes, yes.
Yeah.
Isn't it a must that it must be deposited into an interest-bearing account? It's not that there's an option to this. I might have misunderstood that.
It is an option. You can okay. Let me explain the interest quickly, and we can do it again with the Code of Conduct, and I can show it to you. Is that in our Code of Conduct it says clearly in your contract you must state what are you going to do with the interest. Are you going to pay the interest to the tenant, or are you going to pay the interest to the Estate Agents Affairs Board? Now, in our contract, we say interest will be paid to the Estate Agents Affairs Board. The reason for that is if you do get people working in the bank, then they've got access to the bank system. They can put, say, the 4,000 Rand in, and then in 2 years' time, they will see now the interest is like 138 or 40,000. And then they want that exact amount. When you start calculating, you might get 135,000 Rand. Then you pay them out 135,000 Rand. And I can assure you, you do get that tenant and you're going to get trouble. They will report you at the Estate Agents Affairs Board and you have to explain to the board. But listen, our average, because you must remember, if you pay the interest out, who's going to pay your bank charges on your account? When you put that money into that account, you have to pay bank charges. If you take it out, there's bank charges. To keep that account open, there's bank charges. So who's going to pay for that charges? If you, as an estate agent, pays your bank charges, all the bank charges, I can assure you, you can close your business. You are not going to open for business again, because the bank charges will be closed by the interest that you're going to pay out. So I always say, and that is according to the Code of Conduct and according to the Act, that the interest will be paid to the Estate Agents Affairs Board. Now, how it works is, at the end of the year, your accountant will then audit your account, and then they will work out, okay, say for instance, your interest was like 150 and your bank charges was 120. So the 30,000 difference, you will share it 50% to the Estate Agents Affairs Board and 50% towards your account. So that is how the interest is going. But there is no law to say that you have to pay the interest to the tenant. There's no law to say that. Does that answer your question? Joseph?
Hi, Rina. It's Tulani. Yes, you do, and it did answer me, but it threw me off a bit. So yeah.
Okay, Rina, can I just assist?
Yes, please.
Okay, so ladies and gentlemen, the Rental Housing Act is very clear. It's got two options, right? The first one is you can give the deposit of the tenant to the landlord, and that's where now it is actually preferred that they keep the deposit in an interest-bearing account, right? But then it further goes on and says, if the deposit is given to the estate agent, us here, then that deposit will then be dealt with in terms of the Estate Agency Affairs Act. Now, I want you to just make a note in terms of the section that then tells us how should we as estate agents then deal with the deposit, right? If you go to section 32, subsection 1, you will see that it tells you that you must, in the mandate, disclose to the person giving you the money how will interest be dealt with at the end of the agreement. So if you don't then disclose to the tenant as to how interest will be dealt with, by default, the law says you must then split up 50-50 the interest that you earn on the deposit with the estate agent's fidelity fund. So there are two options there. It's either the landlord, then they must put it in an interest-bearing account. If it's the estate agent that keeps the deposit, it must then be specified in the lease agreement. And then when the lease expires, that interest will be dealt with according to what the lease says. So the practice in the real estate sector is, it's always going to be a split between half the interest going to the outgoing tenant, and then you keep the other half as an estate agent. And the half that you keep, then you must pay half of that half to the estate agent's fidelity fund. So that's how the Act actually, governs the issues around interest on deposits. But remember, ladies and gentlemen, this is one of the sections that is always in the exam, the PDE exam. They will always ask you, how should interest on deposits be dealt with? And that's how it actually needs to be handled. But it's a section that most people don't understand, but we can always clarify this at another forum in terms of how you should actually understand this. I don't know if Tulani, that helps you.
Yes, it does indeed. And then that part where it says the landlord can deduct any expenses, is that also at the end when the interest is paid back, when the tenant is outgoing at that point?
Remember, the deposit is usually referred to as a damaged deposit. If you do something wrong in terms of you staying in the property, then they might actually then want to deduct the money from the deposit to fix it. But in terms of deductions, normal deductions, there shouldn't be any deductions. Remember, even bank charges are not supposed to affect your deposit because there shouldn't be bank charges in the trust account. They should be redirected to the business account of an estate agent. So, and this is the principle that many estate agents don't understand. And when we do audits, most of the time, we qualify them on that basis. So just understand that no expense can be deducted from the deposit.
Okay. Noted,
Yeah.
noted. Thanks.
Yes. Can I just mention something here? Thank you, Joseph. Thanks for clarifying this. Is that in our rental agreement, it says that it is a damaged deposit. But say, for instance, there is an arrears on the rental. Then it also say there, firstly, you must do the damage deposit, and only then thereafter you can take that portion towards the rent that's in arrears. If it doesn't say that in your rental contract, even if you're 10 months in arrears, you are not allowed to take it from that deposit. As Joseph mentioned, that deposit is actually only a damage deposit. Also, when a tenant cannot pay, the landlord cannot come and tell you, listen, release the deposit to me because you have money. That is a damage deposit, and that is first against when a tenant moves out, that you can first utilize it for damage, and if there is an arrears, you can pay it from that. But conditionally, it must state in the contract you're going to do that. Is that correct, Joseph?
That is actually correct. It's just that if you strictly apply the Estate Agency Affairs Act and the Rental Housing Act, the rental should not be substituted by a deposit. It's a practice that it's out there, but the strictest application of what the deposit is meant for is specifically just for damages. But I know in reality, people use the deposit as the last rental. Actually, that shouldn't happen, but it's a security for the landlord. But I just wanted to mention, Rina, and I know you've been in practice for a long time, and the key thing about these deposits, guys, is to disclose to the tenant upon receipt of the money what should happen to the interest when they leave the premises. And often, many times we don't do this. We find ourselves in trouble because now the tenant, when they leave, they'll be asking you to provide the deposit together with the interest. So it's very important that we take note of this because it's always in the exam. Remember, this NQF level 4 is supposed to help you to pass the next exam. So take this to heart. It's very important. Thank you.
Vusi, I think you also had your hand up at the stage. Can you please, do you want to ask something? Vusi? Okay, Vusi is current.
Hi Rina, how are you?
Hello, current.
Yes. Look, Rina. I just wanted to check here. What if there are some outstanding electricity and water bills left behind by the tenant? Can we actually use the deposit to pay those outstanding amounts?
Current, it depends. If there's nothing wrong in the flat and the money is available, and conditionally it stands in your contract that if there is outstanding amounts, municipality, utilities or rental, then you can utilize it for that. If it's not in the contract, you are not allowed to use it for that. Then it's sorry, you have to pay the deposit back. So it's important to make sure that you cover everything in your contract. Does that answer your question? Current? Anybody else? Maxwell? Are you good?
Yeah, I'm okay.
Can you maybe add something on here? Current? Stu? I think Stu said that he's going to be in and out. Okay. Joseph, thank you for adding this. And yes, I'm happy to hear that we know another question that's coming up, and that's about this interest in the exams. So please, guys, we will go through it again. And I think what we must maybe do at a time, do a rental contract quickly, just to cover some of this emergency and urgent points. Is that good?
I agree, Rina, that let's maybe bring up a contract so that we can do these things practically and then the attendees can understand the implications of Rental Housing Act.
Yeah, I think so. What I will do is I will prepare then a rental one for tomorrow evening, and we can do a proper just for the rental and the Rental Act, if that's fine. Because to do the contract is going to be a one-night thing and with the acts with it. You agree with it?
Yeah, I think that just that portion that talks about the interest will help.
Yeah. Okay, but we will, I think it's good if we show it in the contract and we put the contract up, then they can see how it looks like. Okay. The tribunal can conduct a hearing and make a ruling if they cannot resolve the matter by means of mediation. It is an offence not to abide by the tribunal's hearing. Now, I prefer the tribunal. I think they are quite fair and open-minded to this rental thing. And I think you solve your problem much faster than running to the court. Well, nowadays the court is so slow. I think the tribunals are a little bit faster. Mentor discussion. In your class, discuss possible problems with lessees and how to handle such problems. What are the rights of both the lessor and lessee? That will be interested to do as well. I think we must do it for tomorrow night. Okay, any other questions regarding rental agreements and the Act? Okay, then the Matrimonial Property Act and the Immigration Act. In terms of these acts, it is important to keep the following in mind when leasing a property to someone. A spouse married in community of property can let immovable property only with the written consent of the other spouse. A spouse can, however, hire a property without consent from the other spouse. Immovable property cannot be leased to a foreigner unless he or she is in a position of a residency permit. Now, okay, let's quickly say the spouse married in or out of community property. When you list a rental property, it is always good practice to do a proper study on that property. Pull the Lightstone report or Windage report. Make sure who the real owners are of that property. If it's in community of property, you know, sometimes there's a divorce case going on, then the husband wants to rent the property out, the wife wants to rent the property out, and then it can happen that you land up with two tenants at the same time at one property. So make sure that you talk to both parties and that both parties agree to what your mandate and to the tenants that you are going to put into the house. When it comes to the foreigners, I've got always a belief that any foreigner, I'm renting to any foreigner, on the condition that he do have a South African bank account. Because if he's got a South African bank account, you know your monies are safe, and if they pay you cash, you must remember you have to report it at the FIC. And if it's a South African bank account, then you know you are covered. The money comes out of a bank account. There is no trouble or problems that you have. And obviously they will then have a residency permit. And that is how I'm vetting any of my clients. I don't know if I do wrong, but I feel comfortable with that. And I think you are much safer doing it that way. Any comments on that?
Rina, I just wanted to mention that on this Matrimonial Property Act, again, it's also in the PDE 4 exam papers. And the question is always whether you have properly obtained the written consent of the other party when people are married in community of property. Because, ladies and gentlemen, as estate agents, you might be asked to facilitate somebody's divorce without you realizing it. Because maybe, let's say the husband, because it's usually the guys that actually do this in most instances, they will say, no, we want to sell this property, but don't worry about my wife's consent to actually get this property sold or leased. And you go ahead and then lease the property or sell the property, only to find that actually the other party did not consent to selling the property or leasing the property. So just be careful. And also be reminded that Section 21 of the FICA Act now, you have to identify and verify clients. So these acts, as you read them, as Rina is going through them, think about the other pieces of legislation that are applicable to our environment, because you're not supposed to read them in isolation. Remember, Section 21 says you must identify and verify your clients. And this is now the Matrimonial Property Act, where it says you must get a written consent of the other spouse that is married in community of property. Please, please, ladies and gentlemen, always ask the question, are you married? If they say yes, you ask how. If they say married in community of property, then you need to obtain the written consent of the other spouse. Please, ladies and gentlemen, thank you.
Yes, thank you, Joseph. Thanks for that. And if they are not sure how are they married, they can accept as if they are married in community of property. Because if you're married out of community of property, you know for sure you've signed an agreement. So if anybody tells me I'm not sure, then I accept that they are definitely married in community of property. And also another thing is that, say for instance, the husband and wife is busy with the divorce, and the husband decides now he's going to buy a property, and then the wife said, oh no, it's fine, I will sign with you, it's not a problem. Remember, it is a problem, because the moment she signs that document, then she is half of that property is hers, and you can do what you want. It will be registered on both parties, and then only after the divorce he will find out that you have to share the flat or the house with her. So if they're busy with the divorce, just let they divorce and then let they move on and buy what they want to buy. Any questions? Stamp duties. There is no stamp duties on residential properties anymore unless it is for a longer period than 10 years. Or 5 years, sorry, 5 years. And that is also not included in residential properties. It is only on the commercial properties. If you sell a property where there is commercial, then the commercial must be the square meters of the commercial properties must be bigger than the residential properties. So for instance, it is a 200 square meter property, then your commercial must exceed the 50%. So it must then more than 100% before the SARS can have a look on maybe a rebate on the VAT or the VAT clearance. Yeah. The lessor's obligation at common law. Now, common law there's quite a lot of things that is under common law, and it does not have to be in a contract written. Like you don't say there, you know, I'm safe, my mind is, I'm open-minded, I'm not, you know, things like that. You don't have to say, they take it as if you sign, you know what you're doing. So there is things that they don't put in a contract, but it is still legally enforceable. If somebody then realizes that this guy is not safe-minded, then they can cancel the contract actually, if they can prove that, but then it must be a document through court. The lessor must deliver the property agreed upon along with those things without which the property cannot be properly used, like the keys and remote controls. The property must be reasonably fit for the purpose for which it is let, and it must be in the condition it was at the time of conclusion of the lease. The lessor must provide undistributed use of the premises on the date as agreed. Payment of the cost of executing a lease is normally regulated by the agreement. If a lessor breaches the lease and the breach is material, the lessee has a choice: either to abide by the contract and claim specific performance and such damages that he or she may have suffered, or cancel the contract and claim damages. If the breach is not material, the lessee is confined to damages, and the court has discretion whether or not to grant specific performance. It is the lessor's duty to maintain the premises in a good condition, reasonably fit for the purpose for which they were let. Repair doors, windows, roof, etc. If damage is caused due to negligence by the lessee, the lessor is under no duty to repair it. The lessee is, however, entitled to a reduction of the rental proportional to the reduced use and enjoyment in the defective premises. A lessor may recover damages from the lessee for losses sustained due to the lessee's breach of an obligation to maintain the premises in the event that the parties had agreed that the lessee would main the premises. The parties may also agree that the lessee is liable for the payment of rates and taxes. Any questions? Okay, legal requirements, complete this activity. This is on your own single activity. In terms of common law, what are the tenant's obligations towards the property owner? Discuss what is meant by options to renew and right of preemption. Describe what is meant by subletting, assignment and cession in terms of a lease agreement and common law. The lease agreement, a valid lease agreement, which does not have to be in writing to be valid, comes into being once the parties have decided on. The fact that the property is to be leased from the lessor by the lessee and that this is their intention. The exact description of the property, example, the lease premises and the obligation to pay rent by the lessee and the agreed amount. it is good business practice for a lease agreement to be executed in writing and signed by the lessor and the lessee on their duly authorized representatives. You know, if a landlord is renting directly to a tenant and you as an estate agent are not involved and they do not sign a lease agreement, then that lease agreement is a verbal lease agreement for now. It's also valid. I know that they're busy with changing that one as well. But if we as estate agents are involved, I never do any verbal agreements ever, because at a time they will start changing some of the agreed options. So in my business, I always say you have to sign a lease agreement in writing and let all the parties sign wherever is necessary. Then you know you are covered and there cannot be any comebacks to you. Any questions? Karen?
Hi, Irina. I was cut by connection before I could come to the end of my question recently.
Yes.
Yes, look, Irina. There was recently there was a challenge. You know, there was a dispute between a relative of mine who happened to be leasing a property to a tenant. What happened is that on the final month, the tenant didn't pay the rent, and then he just moved out without paying rent. And then he claimed that, you know, the landlord will actually deduct the money, I mean, for the rent on the deposit. And then what happened is that there were also damages in the property, and then the tenant said all the damages that were there, he actually found them there. They were there before he occupies the property, so he's not liable to pay any damage. So the money for the deposit should go directly, I mean, as money for the rent. And then another thing that happened, there were some outstanding electricity bills, and then he didn't pay that I mean, the outstanding money. He didn't pay anything. He just said, you know what, you can take the deposit as my monthly rent this month. So I just wanted to check with you, how can the landlord, you know, get justice in this kind of a situation? Because I'm like you, Rina, I don't get involved in the property deals of relatives, and neither do I, you know, recommend other agents, because I'm avoiding such situations.
Okay, Karen, can I just ask, did he sign a direct contract or was there an estate agent involved?
There was an estate agent involved.
Okay, well then I assume all the documentation will be in place, like your inspection sheet, you know, the contract and everything, and then they must report it at the tribunal. Take them to the tribunal, and you can still, even if they moved out, you can still go to the tribunal. That's what I would have. That's what I would have suggested. I can assure you, to go to court nowadays, you're going to wait a long time. And it's going to cost him a lot of money. But however, in the contract, if the state agent's contract is according to the Act, there will be a clause to say that the tenant will also be liable for any legal cost. So that he can also claim legal costs there if there is any. But also late payment fees, he can claim that, I'm sure. He can get that contract and send it through to me, and we can have a look at it and we can advise on that.
Oh, okay. Thank you, Rina.
Any questions? So, Karen, I can just mention on what you said is just what we also said, is that the deposit cannot be utilized for rent. And it must be in the contract, and the estate agent must also, you as an estate agent, you must explain your rental contract to your tenant. It is so important that he knows from day one he cannot use the deposit for rent. He has to pay the last month's rent, and that's finished and clear. And also, when it comes to damages, he's liable for damages. And what I also tell my tenants with a contract, you know what, I'm giving you a clean apartment. It is painted, and that's how I want it back. So if you want to paint it the same color, I'll give you the name of the color of the paint, and then you can do it. Then we give you your full deposit back. And I promise you, if you explain it to your tenant clearly, you will never get any problems. And then they will, in most cases, my tenants paint the flat because they know if I paint it, it's going to be a few $1,000. If they paint it, it's just going to be less than R1,000. So it's always very good practice to make sure that they know exactly what's in the contract. Also, when they don't pay, this is the other thing that I can just maybe touch on. Maybe we'll get it later on, but while it's in my head, let me just see is that if the, no, sorry, there was a call coming in. If, no, I've made. I'll come back to it now. Sorry, my apologies. Oh. Okay, administrative. Oh yeah, this is it. If you have cost, like if this is the thing, if in the law it says in the Credit Act that you cannot take action against a tenant before the 7th of the month, meaning that you cannot hand them over to the tribunal. Neither can you hand them over to a lawyer or anything because of non-payment. However, what you can do is you can start with action. On the first day of the month, rent is payable on the first day of the month. If it's not paid on the first day of the month, on the 2nd, I will send an SMS asking my tenant, please send me proof of payment. If they can give me proof of payment, I don't charge them any cost. But I always tell my tenant when they sign the contract, when you make the payment, send me proof. Because if it's over a weekend, and on a Monday morning, if I check my account and the money is not there, I am going to send you an SMS. That SMS is going to cost you 35 Rand. It's a lot of money. It's going to cost you 40 cents or whatever to send that SMS. But you know what? I don't want to send that SMS. I prefer the money in my account. So that's why I'm charging. If it's on the 3rd day of the month, it's not there, then I send an email. On the 4th, I send a letter. For each action, he is going to pay. And that must also be in your contract. And what I have is next to that, I've got an initial portion where he will initial. That is the amount that I'm going to charge him for. And you know what? Since I've done that, I'm not calling anybody ever for money. So it is a nitty-gritty thing that, yeah, you must be strict with your tenants. From the first day, the money must be in your account. Finish and clear. If it's not, if they haven't sent you proof of payment, you start charging. And then also a late payment fee. On the 7th of the month, you can start doing the late payment fees as well. Remember, you must take care of your landlord. He must start paying his bond. Always tell your landlord, arrange with your bank that the money will be in, or you will do your payment on the 7th of the month. Then you know for sure by then the money will be in your account. Okay, an estate agent can be given a mandate only to find a tenant for the land, a lessor's particular property, example, procurement of a suitable tenant, or to also administer the lease for the full duration of the term of the lease.
Hi, Rina.
Yes, hello, Kabela.
Sorry to take you back.
Okay.
Just on what you were saying, on the other side of the fence, what if as a tenant I signed an agreement that says that you'll be charged a penalty if you do not pay rent by the 1st, but it's not specified. Then I receive a letter that says I'm charged 10% of the rental fee for not paying on the 1st. Is that legal? How can that be countered? Because it was not specific to say, like you're saying, SMS 35, email 100, late payment fee 1%. It just said that a fee is payable.
I must say one thing, Kabela, and that is where it's very important to read an agreement before you sign it. If it says there a fee, it's an open thing, and I won't say it's illegal, but it's very dangerous put a wording in like that. You must be specific. Remember, a contract must be specific. And that is so important. If you get a contract to say that a fee will be charged, you stop it there and you say, tell me what is the fee? Is it 1%? Is it 0.5%? Is it 100 Rand? Is it 200 Rand? Put an amount in there. It is too dangerous because then they can charge you whatever they like.
All right. Thank you very much for the clarity.
Okay. And remember, you know what? It's not good business practice, I will say. It's not wrong. But a rental is the same as an offer to purchase to buy. If a purchaser, a tenant comes to you and say, you know what, maybe you advertise for 6,500 Rand, and now he said, but you know, I can only pay 6,300 or 6,200 Rand. Negotiate with your landlord and try to help the tenant. I always say negotiation is a good thing. And if you start negotiating on that or help the tenant to fix a few things in the apartment, let the landlord pay, you will gain confidence with that tenant. And then you will not have problems when it comes to payment day. If he has a problem, tell them up front, on signature of your agreement, please talk to me in advance so that I know there's going to be a problem. Okay, tenants must read written receipts for all payments made. The written mandate must be set out in such a way that it is clear that the lessor is authorizing the agent to act on his behalf in administering the lease in terms of the following. Find a suitable tenant, draw up a lease agreement, collect a deposit, do the inspections before and at the end of the term of the lease, attend to property maintenance, collect arrear rentals. So you can work your fee that you're going to charge your landlord. Are you only going to procure? Are you going to call him when there's any maintenance to be done? Or are you going to oversee any maintenance where you will use contractors and make sure it's done, where he's just receiving his money, doesn't want to know anything about it. So you can actually work your fee out according to that. Try to answer the following questions without referring to your notes. And I think this one is a very important one. Joseph, is this not also in the questions? Try to answer the following questions without referring. If you find that, okay, which of the following statements concerning the conclusion of a lease or immovable property are correct? A common law, a lease of immovable property is invalid unless the lease is in writing and signed by both the lessor and the lessee. The amount of rental is agreed upon. The lessor is the owner of the leased premises. Let's take a guess. I'm not doing every time all the activities, but let's take the guess on this one. I think this can be quite interesting. Can anybody on the floor take a guess?
I think the last one, it's Kwastabile, the lessor is the owner of the leased premises.
Now, the lessor must be the owner of the leased premises. Is invalid unless the amount, at common law, a lease of immovable property is invalid unless the lease is in writing and signed by both parties, the lessor and the lessee. The amount of rental is agreed upon. The lessor is the owner of the leased premises. It cannot be invalid if the lessor is the owner, because the lessor must be the owner. It can also not be invalid if the amount of rental is agreed upon. It can also not be invalid. Joseph, help me on this one. If the lease is in writing and signed by both, because if it's in writing, it's better than just verbally agreed upon.
Rena, Joseph excused himself here to attend another session.
Okay, that's great. Okay, thanks, Nomisa. Nomisa, what is your feeling while you're on this talking?
Personally, I think none of these things are invalid. It makes the contract invalid because you have to be the owner and you must agree on the rental amount and both parties must sign. So I'm not sure if I think it's a trick question. I'm not sure.
I think it's a tricky question, but yes, it's as I will say none. Which of the following is correct in order to conclude a valid lease agreement? The rental must be fixed by the parties themselves and cannot be left to be determined by a third party. The lessor need not necessarily be the owner of the property let. The amount of the rental must be market related. The period of the lease agreement must always be specified. The rental must be expressed as a defined sum and not by means of a formula. Now the question is, which of the following is correct in order to conclude a valid lease agreement? Will you say number one is correct? The rental must be fixed by the parties themselves and cannot be left to be determined by a third party. I will say it's correct, is it? Because you cannot leave it open and we as the state agent can decide now, listen, we're charging X, Y, Z. The lessor need not necessarily be the owner of the property. That's wrong. The amount of the rental must be market related. It's advisable. The period of the lease agreement must always be specified. Yes. The rental must be expressed as a defined sum and not by means of a formula. That's also correct. Okay. Any questions?
So, Rina.
Yes, Kabela.
The lessor need not necessarily be the owner of the property let. You say that's wrong. So meaning the person who leases out must be the owner.
Yes. The owner must give you the mandate.
Oh, okay. All right.
Yeah. I cannot take Nomisa's property and rent it to you because I just like to do it. She must give permission to do so.
All right. Can I take you back just one slide?
Yeah.
Just one back before the activity. The maintenance. I was under the impression that, let's say on a rental, for a lack of a better word, I'll call it minor maintenance, should be done by the person who's leasing the property. Or is that what must be agreed upon between the lessor and the lessee? Okay.
Maintenance is you get wear and tear.
Okay.
Wear and tear is the owner's department. Other maintenance, like for in case, I just had a case where plumbing.
Yeah.
Normally when a sewer gets blocked, I will call a plumber and say, go and have a look. What is the cause of the problem? If it's the tenant throwing rubbish down the drain, you know, it happens that kids throw toys down the drain without knowing the parents' knowledge. Ne? So it depends what caused the blockage. In the instance, what I've got now is the roots through all the years grow through the pipe. Can you believe it? It happened. There is a ceramic pipe. And we had to change the whole pipe. So that I cannot hold the tenant responsible, even because the blockage was because of stuff that I throw down the drain. But if the roots was not there, it could have gone through. So the owner had to pay and fixed, changed that whole pipe. So yeah, it depends what type of maintenance it is. I always say to the tenant, you know, if there's a seal of the water leakage, just do it. It's going to cost you less than 10 Rand. But for the owner to send out a plumber, it's going to cost like 700, 800 Rand.
At the expense of the person.
Then it's the expense of the owner because it's normal wear and tear. So you must decide when you stay in a property, you know what, are you really going to bother the owner with that? You must consider that if you are a good tenant, not complaining so much for a little leak or small things, then when it comes to increment on the end of the year, the owner will be also more lenient to say, you know, I rather would like to keep this tenant instead of increasing his rent. But if you complain of nitty-gritty things and he must pay out, then he's definitely going for the 10% increase.
All right, one more question from my side.
Yes.
So as the as the property practitioner, how do you deal with an instance where a property is a multi-let, like it's one big house, let's say, with multiple rooms in there, the showers and the bathrooms and the kitchen and everything is common property is being shared, right? Then let's say the people renting there, they break the shower glass. We know it's their fault, it can't just break. Do you charge that? Do you find the culprit or you charge that across?
If you cannot find the culprit, then you charge it across. And I promise you, once you start charging across, the people who's not liable for it will quickly say who it is. But it's always good practice that if it's a multi-let, is to form like is it a community? You know, representatives. So that they can decide between themselves. You as the estate agent, the property practitioner will give out rules and regulations, and then they will oversee that rules and regulations to see that everybody adheres to the rules and regulations. For you to step in there, it's headache. I promise you, it's headache.
All right, thank you.
Yeah, if it's a small multi-let, I will rather say let it to one person and say you can rent it out. Rather allow them to sublet, conditionally that you sign in the contract that when they move out, the main tenant move out, everybody must move out. Okay, does that answer your question?
Yes, ma'am. Thank you very much.
God, pleasure. Okay, I'm not going to answer do the rest of the questions, otherwise we're not going to finish tonight. After sales service, once a sale has been negotiated and closed, there are still many tasks and duties that need to be undertaken by the diligent estate agent. These duties relate to the documentation and administrative tasks concerning documentation that must be completed and submitted timeously, as well as management of any outstanding conditions in the contract. All legal and financial aspects of the sale must also be explained to the parties, as well as the process of conveyancing and registration of the property ownership. Effective communication of all these aspects is a necessity in order to ensure satisfied clients and ultimately repeat business. Completion of relevant documentation. An estate agent is obliged to furnish buyers and sellers with copies of the agreement of sale or other documents signed by the client as soon as they have been signed. The original contract or a copy thereof must be delivered to the conveyancer that has been elected to see to the registration of transfer. And just to answer a question that came to me today is that it is only a conveyancer that can do the registrations in the deeds office. We as property practitioners does not get involved in that. Our job is to sign the contract, make sure that the buyer gets the finance, everything is in place. The COC will be done by the seller, and your inspection form is, or the snag list has been completed. That is our department. But the physical or the actual registration of the bond or the cancellation of the old bond or the registration of the new property into the name of the purchaser. That is the conveyancer, and they are registered to do so. We as estate agents are not registered to do so. Sometimes the parties wish to amend certain clauses, or the seller is willing to relieve the purchaser of certain obligations in terms of the agreement. All variations of material terms of a contract of sale of immovable property must be in writing and signed by the parties. The following can be amended in this way. Variations read the price, the property and the parties. Variations read the mode of payment. Variations read the date of possession and the passing of the risk, the liability of transfer cost, the duty of renovations to the property, the passing of encumbered ownership. I can just mention to you the transfer cost. The seller can decide, say for instance, the purchase price is 1 million and the transfer and the bond cost will say be 50,000 rand. This is just a thumbs up, it's not the real figure. So the total price is 1.50. You can only apply for R1 million for the bond, and then this purchaser must then have 50,000 cash to pay for the transfer and the bond cost. When he gets his approval from the bank might turn around and say, no, boy, I'm only going to give you 980. So you've got a 20,000 rand shortfall, and the seller, the purchaser say, but I don't have that 20,000 rand. Then you can go back to your seller and say, Mr. Seller, please pay the transfer cost. Then my client can then do the bond cost. Then that is what they meant by that. Then the seller can come up and say, okay, he will be liable for the transfer cost. That will give you, he will actually drop the price by, say, 20,000 rand. But instead of dropping it on that way, you change the liability, who's going to pay the transfer cost. But by law, the seller are not allowed to pay the bond cost. He can pay the transfer cost, but not the bond cost. Any questions to this? The question of rectification to allow mutual mistakes in contracts of sale of immovable property to be rectified is possible under the following circumstances. If a material or essential term that is incorrectly stated in the agreement can be rectified in the event that the document as it stands is a valid sale, a property description and a price, but they are incorrect stated. Rectification cannot be sought if the parties are in dispute as to what their initial agreement was. The remedy of rectification is to allow the parties to a contract to have the court correct their contract so that it reflects their true intention. Any questions up to here? Loan application. Both the buyer and the seller must be attended to in many ways after the sale has been concluded. Both these parties must be given a copy of the deed of sale, and the buyer's deposit in terms of the agreement must be paid into the agency's trust account. The agent must ensure that the buyer has applied for the necessary finance in terms of the sale agreement. If the buyer needs to obtain finance, the agent can either, with the buyer's consent, arrange for a bond originator to contact him or her, or complete the loan application form for the buyer and ensure that it reaches the bank and is processed by the bank timelessly. You must remember now with the POPI Act, the buyer must give you written permission to use his information. What we suggest is that in your contracts, it must state that it gives you permission to use his information to complete a successful sale. That will cover you for everybody that you will give his information through. If the loan application is not approved by the bank before the cut-off date as stated in the deed of sale, the agreement is no longer enforceable. The agent must therefore be aware of the timeframes and ensure that these are adhered to. as the sale can fall through if the suspensive conditions are not met within these timeframes. The agent must provide the conveyancer with as much information regarding the buyer and seller as possible, as this will speed up the conveyancing process. The agent must follow up with the conveyancing attorney and keep both the buyer and seller informed to the progress that is being made with the mortgage loan application, if any, and any other conditions agreed on in the deed of sale, as well as the transfer and registration of the property ownership into the name of the buyer. The following information and documents must be delivered to the conveyancer: a copy of the original deed of sale. Now, we as estate agents, if the seller has the original deed of sale, I always ask them to hand it to the attorney when they go and sign the documentation. We do not really handle the deed of sales. A copy of the seller's and buyer's ID document or passport, the page with a photograph if the parties are natural persons. Copies of the relevant documentation and resolutions if the seller and buyer is a legal entity or trust, example, copies of the company's memorandum, articles of association and certificate of incorporation, copies of a closed corporation, founding statement and copies of trust deed. Buyers and sellers' telephone numbers, fax mail numbers and email addresses. The seller's property is mortgaged, the bank's name and account number. If the buyer requires a bond, the responsible person for the application, the buyer's estate agent, bond originator, bank statement. Confirmation that the deposit has been paid in terms of the agreement, a copy of the marriage certificates if the buyer and seller, if married, and a copy of the front page of their antenuptial contract, if so married. If the transfer is linked to another transfer, it must clearly be indicated to the conveyancer, and also the name of the conveyancer who addresses it. That is why we've got that personal information form on all other contracts, because then it covers all these questions and information that you must send through to the lawyers. So if you read it like this, you want to run away, but it's not really. You have that information sheet and it will cover you up. Any questions? Complying with legal and financial obligations, the estate agent has a duty to assist the parties in understanding the importance of complying with legal and financial obligations in terms of their transaction. An estate agent needs to be sure that the agreement of sale has been accurately filled out and that the necessary documentation needs to be prepared in order to ensure that the following information is gathered timelessly. In all transactions, requirements of the Financial Intelligence Center Act must be complied with. This act compels the agent to properly identify the client and to report suspicious transactions to the Financial Intelligence Center. Identifying clients is quite onerous, and it is imperative that one should not simply accept photocopies of identity documents as they could be produced fraudulently. I've got the rule that if I ask them for their ID documents and I'm taking a photo with my cell phone, it's better, it's safe, then I know it's the one that I've taken. They cannot, I cannot miss a figure or something in the ID number. The original passport, identity, marriage certificate, antenuptial contracts, and other important documents must be obtained. The onus rests on the estate agent to ensure the compliance of the Act. The offer to purchase, deed of sale, sale agreement, contract must be completed with care and skill by the estate agent and within the agreed and necessary time frames. The need for accuracy and urgency cannot be overemphasized when completing these formalities and other supporting documents. The deed of sale consists of an offer to purchase that is made by the buyer to the seller and is accepted by the seller. On acceptance, the buyer and seller are bound to the terms and conditions as set out in the deed of sale, and it is the estate agent's duty to ensure that the agreement is valid and enforceable. In order for the deed of sale to be valid, it must be in writing and contain the seller's name and ID number, the buyer's name and ID number, the purchase price, a description of the property being purchased, the fact that the contract is an agreement for the sale of the property, the signatures of the parties of or their agents acting on their written authority, any material terms that the parties have agreed on. In order to comply with common law, the following requirement must be met. In order to comply with common law, okay, the following requirements must be met. The parties must reach consensus and intend that the terms set out in the agreement constitute a binding agreement between them. The parties must have the necessary capacity to enter into the agreement. The contract must be lawful. It must contain the formalities and performance in terms of the contract must be possible at the time of the contract. Due to the complicated nature of the above state of affairs at common law, it is necessary for the estate agent to ensure that both parties to the sale come to agreement regarding fixtures, fittings, and accessories. The sale agreement should spell out the parties' intentions in writing, and any terms that could be disputed over should be specifically mentioned. Special clauses and addendums, there are always some special clauses in the deed of sale that need to be explained to the parties as they place an obligation on either one or both of the parties. Special clauses can also be contained in an addendum to the contract which is signed by both parties simultaneously with the main body of the agreement. Like for in case, if it's a rental agreement, the tenant will maintain the pool for in case, or the tenant will maintain the garden. So that is special clauses that you will bring into your contract. The electrical compliance certificate, while the electrical certificate is a requirement in terms of the Occupational Health and Safety Act, it is not necessary that the electrical certificate be lodged with the Register of Deeds for transfer purposes. The absence of an electrical certificate will therefore not affect the transfer of your client's property. However, because it's in the contract, normally the attorneys will not lodge if that is not part of the documents. When a property is sold, the new owner will require an electrical certificate of compliance before the local authority will connect the electricity supply. It is common practice for the seller to be required to furnish such a compliance certificate to the purchaser. The seller may have to instruct an electrician to effect repairs to the installation before the electrical certificate can be issued. Now, I just want to stop here for a while. You get your electrical compliance certificate, you get a gas certificate, and you get a electrical fence certificate. That is what we need here in Gauteng. Now, you must remember, say for in case the electrical compliance certificate, if a property is sold and there is a certificate and you as a new purchaser moved into the house and now you realize that, you know, the certificate said all the plugs is fine. But if I put this plug on my stove trip or anything went wrong, so then I call my friend that's also electrician. I said, please come and just have a look for me. And then he said, but you know what? The DB box is wrong. This is wrong. This is wrong. Then you don't go to the seller. You go to the electrician, because that electrician is also under a code of conduct. And it's the same as an NHRBC certificate as well, if it's a new property. He must come and fix what he said it was right, and it is not right. So that is under his. He must then claim that money from the seller. It's not your job to claim it from the seller. If it's under the electricity, if it's under the gas certificate, if it's under the NHRBC, if it's under the electrical fence certificate, because that said, they are also registered at boards, and if they do not want to come and fix it, you go to that board and you put a complaint in at that board against that specific contractor, because they have to make sure that whatever they write there is correct. Any questions? The contract of sale used by good estate agencies have specific clause relating to the electrical certificate of compliance. Failure to produce a compliance certificate will therefore constitute a breach of contract, and the affected party may recover damages or take any recourse that the contract or common law allows. The certificate should be retained by the purchaser to hand to the next purchaser when the property is again sold. A new electrical certificate will only be required if there has been any addition or irritation to any electrical installations subsequent to issue of the existing electrical certificate of compliance. An electrical certificate of compliance remains valid and becomes transferable upon the sale of the property for so long as there are no alterations or additions to the electrical installation. If any alterations were made, a new compliance certificate would have been issued for additional alteration after an inspection of the electrical installation by an accredited person in terms of the Occupational Health and Safety Act. I know that there it is. Some electrical certificates have an expiry date. These electrical certificates typically expire 6 months after the date of issue. That's why the attorneys will, in any case, request a new electrical certificate every 6 months. In most sale agreements, the seller undertakes to obtain a new electrical certificate of compliance, even where no alterations or additions to the existing electrical installation have been effected since the issue of the previous certificate. This requirement, thus, while commendable and designed for the protection of the purchaser, is not restrictly necessary in terms of the Occupational Health and Safety Act. Electrical installations are inspected and tested according to the code of standards that prevailed at the time of the property in question was built. A number of items will, however, become compulsory from 2002, irrespective of the date of the original installation. Earth leakages, plugs with shutters, and LV surge protection as a requirement for electrical installations will become law as from 1st January 2005. Now that we know is already there. Activity. Yes, Kabela.
Before we get to the compliance, specifically, who must be approached in the event that an electrical certificate has been issued and there's something wrong? You know, if you Google, they'll tell you about 100 boards, electrical, ECA, SA, this, that. Which office must be approached in the event where there's something faulty with the electricity, but the electrical certificate has been issued, except for the Consumer Protection Act.
Okay, when you as a new purchaser now move into your house and you experience there's quite a few things wrong, you must get that. It's not a copy, you must get the original. It's a yellow page document. I will get one and I will put it up for you. And you will have that document. You have to ask the attorney for that document because normally it's with the attorney. Then you will contact the electrician who did the inspection. His company name, his personal name, his registration number, everything is on that certificate. You contact him and say, listen, you have issued this certificate now 1 month or 2 months ago. By the time that you issued the certificate, you said there was nothing wrong. I want you to come and have a look. I've just moved in here. I think there's quite a few things wrong. Try to get him to your premises. Then he must test again in front of you. And then he is liable to fix that, because if he's not liable, if the owner maybe changed it since he did the certificate by the time, then you have to go to the owner. But it's in 1 or 2% of the cases that happens. Mostly the owner, the electrician will be a friend of the owner, and the owner will just tell him, just issue this thing and I don't want to fix anything. Then they issue it, you do get it, but it's not a common thing that happens every day. So if you claim from the contractor. It is the contractor who signed that document who states everything was in order. If there's anything that he must come and fix, that money, he must get it from the seller, not you. Does that answer your question, Kabela?
That's one part. In the event that the electrician or what does not want to come over.
Okay, then you tell him, okay, fine, it's fine. If you don't want to come over, I'm going to report you at the board. Then you get an electrician, you get an opinion, and then you send it with that certificate to his board, and for surely he's going to lose his license. So no electrician, it's the same with us. just threat us with the board, then we do what we have to do, even if you are not guilty. So he will come and fix it, I can assure you.
I'm looking for that specific name of the board.
Okay, I'll give it to you. What I will do is I will get a copy of an electrical certificate. Then you will see exactly what's on that certificate. I think that then it will answer all your questions.
Thank you.
Okay. Any questions? Maxwell?
Hi, Rena.
Hello, Maxwell.
Let's just say in this case, you just purchase a new property, you move in. 6 months down the line, then municipality, they came and installed the, let's say, the timer for geysers just to save energy. If it happens, is there a change of proposal that need to be signed by the municipality, the person who's occupying the house, and the electrician?
Yeah, if there's any changes, then it is the if it depends when it was done. If it was done after registration, obviously the new purchaser or the purchaser will then be liable for it. If it was done prior to the registration date, then the seller will be liable for it. That is in our contracts. It states that liability goes over on date of registration. Does that answer your questions?
Not really, because remember these guys from municipality, when they installed the timer for geysers, they will come with their electricians. So what if something wrong happened in the DB, then there's a fire?
Is this now after registration?
Yes.
Now then your purchaser, the guy who's staying in that house, he's the liable part. You have to, he must make sure that that electrician is doing his job properly. And then they must also give you a new certificate.
Yeah, but if I'm not electrician, I won't even see what is he doing. He will just say, things are okay, that's okay. Then he says sign here, then I'll sign, because I'm clueless. I know nothing about electricity.
Then it's between you and the municipality. But I can assure you one thing, the municipality is using electricians. They can be very faulty in quite a number of ways, but there they use electricians. I know some of the electricians at the electrical department, so that's why I know. So I don't think that is a big problem. I haven't come across something like that. Look, PK?
Okay.
We'll come back to that one as well. I'll find out about that, but I know that it will be between you and the municipality.
Okay, Rena, just to try to answer that question.
Yes.
So basically, if the municipality installed the geyser timer, so when they give you a COC, they give you a COC for that geyser timer, not for the whole building. So should anything happen on the DP box, because when they install a geyser timer, they also touch the the DP box. Should anything happen, so they are accountable. They need to come and do some checks to check to verify whether whatever problem that happened, is it what is the geyser timer, the installation of geyser timer, is it the one that caused the problem or not?
Yeah, yes. Sorry,
yes.
You can carry on.
Yes, and then from there, should they find out the reason for the box to go off or to ban, whatever the case, that means that those guys will be liable, but not for the whole people, only for the DB box, that part. When they give you COC, they specify specifically that is specifically for that part.
Yeah. Now, I agree there may be one of the plugs, as you say, they install that and they touch it and something went wrong there, then they will be liable because they worked in the DB box.
Yes, but now not on the plugs. He has nothing to do with the plugs. So if something happened in the plugs, they are not accountable. They are only accountable or liable for the DB box. On their COC, if you read it as well, it also states that as well.
Oh, okay. All right. Thank you for clarifying that.
Okay, thanks.
Thank you. I appreciate that. Any more inputs? Okay, it's the electrical compliance certificate. That is the activity there. Beetle infestation certificate. We here in Gauteng doesn't get that unless it is a thatch roof. Then the banks can request that. So we normally do not do the beetle infestation certificate, but definitely Western Cape, KwaZulu-Natal on the seafront, there you do it. Communication management between parties. The estate agent has specific legal and ethical obligations towards a client that also apply as part of after-sale service. These obligations need to be managed by meaningful and ongoing communication with the parties involved in the transaction. The following areas need to be managed in order to ensure that no misunderstandings occur during and after the mandate has been fulfilled. The terms of the agreement with the mandate, representations made on behalf of the mandator, the mandator's expectations, the fiduciary relationship that exists, and the nature of the remuneration payable to the agent. The agent should also follow up on the conveyancing procedure and report any progress that is made to both the buyer and the seller. Terms of the mandate. An agreement is reached with the mandator when he or she instructs the agent to sell a property. A mandate can also be given by the buyer of a property. The normal, okay, let me quickly explain that one. Say for instance, you have a buyer and he can tell you, I'm looking for a 4-bedroom, 2-bathroom, etc., etc. Then he gave you a mandate to look for him for a property. So you can then actually have a selling mandate and a buyer's mandate to sell that property. That is what is given by the buyer. The normal terms of such an agreement would include an undertaking by the seller or buyer, as the case may be, to pay the agent an agreed amount of commission on fulfillment of the mandate. If the conditions for fulfillment are not expressly spelled out, it can be assumed that if the seller is the mandator, that the agent must introduce a willing and able purchaser who enters into a binding agreement with the seller. Where the mandator is the purchaser, the agent also needs to bring about a binding agreement of sale between the purchaser and the seller, but the agent needs not to have financially qualified the purchaser as he or she is now the mandator. Representing the mandator, the estate agent does not normally have a power of attorney to bind his mandatory in terms of a contract, but he or she does have the right to do certain things as the mandator's representative. The estate agent can, for example, make representations.
I wanted to the interview.
Sorry,
they want to negotiate salary, but a problem is going to be like, I won't benefit anything because I have to travel.
Is it Vusi or Tulani that speak now? I couldn't hear. Sorry, the line was breaking up very, very badly.
Irina, just a question.
Yes, please.
I think it's written somewhere in there, but my English megabytes are depleted. In the event where a buyer gives a mandate to an estate agent, because now, if let's say me as a property practitioner, a buyer comes to me, I want a 4-bedroom, 2-bathroom, then I start looking for a property, and I find a property that's not on my list, meaning there's another agent on the other side who's selling. I speak to that agent. I have a buyer who wants to buy this house because it matches his or her requirements. How does now the commission work? Do I get my commission from the buyer, then that agent gets it from the seller, or how does it work now?
No, what we normally do is, say for instance, I'm just going to do a thumb suck on the percentage now as well. Say the purchase price is or the selling price is 1 million and the commission is 100,000. So the total selling price is 1.1. It depends on the agreement between you and that estate agent. They are the listing agents and you are the selling agent. When it comes to development land, we normally split 50-50. When it comes to residential, there can be a split of like 30-70 or also maybe 50-50. So it depends on the other estate agent. Then you sign a commission agreement with that contract to say to the seller, Mr. Seller, your property is being listed by ABC. I'm from Pormat, and so there's the two agencies on the row. And let's assume you're going to split 50-50. So then in that commission agreement, you instruct the attorney to pay 50% of that commission to ABC and 50% to Pormat.
All right, thank you for that.
Does that answer your question, Camilla?
Yes, ma'am.
Okay, thanks. Any more questions?
Ludwig has a hand up.
Ludwig? Yes.
Yes.
Thank you.
Okay. I don't know if I got Kabelo's questions right, correct. Kabelo, were you not asking whether the buyer is the one who give you commission, not the seller?
According to the sale contract, the seller is paying the commission.
Yes, that's what I wanted to correct as well, because I think according to Kabelo, you mentioned the buyer. You are saying that if the buyer is that buyer is the one who's going to give you commission?
Now, I think what you actually asked, if I understood it correctly, Kabelo, you can help me, is that he was asking, is there now two parties going to pay the commission, like the buyer will pay us that has got the mandate to find the property, and the seller is going to pay his agent. So it's like a double commission. So no, it's not that. Is that what you asked, Kabelo?
Yes, that's what I asked, because, you know, when we come to, let's say there are people who are particular, you know, I want this and that and that. And unfortunately, if you passively look on the internet, there's nothing. So rather get your own headhunter to look for that. So that's exactly what I was asking, Rin.
Yeah. Okay. You know what? If the prices are very good and you can negotiate with your purchaser, it's not against the law if he agrees. But then everything that is agreed upon must be in the contract. So you have to put it in the contract so that the seller knows that he's going to pay you also commission. Otherwise, there must be a commission agreement and who's paying what. Okay. Representing the mandator, okay, there an estate agent can also give guarantees with respect to property characteristics like the availability of water, of irrigation, as he will probably be buying. Yes, Kabela.
Sorry. I think I just want to ask this question. Is it ethical, let's say in that event now, a buyer came to me saying they want this house, then I'm going to negotiate that commission with this property agent on the other side, but they're not budging. And the contract they signed was not a sole mandate. Can I then dial direct to the seller to say, hey, chief, listen, I have a buyer here. Let's do a deal. Like, is that legal, ethical? What am I working on?
Okay. If that estate agent, you must remember the party who is the effective cause of the sale. If that estate agent introduce you to the property, they can claim commission. If they does not have a sole and exclusive mandate, I have done a transaction like that in my life. I'm not 100% sure if it was right, but I've done it. Is I went to the seller and I said, Mr. Seller, I've got a buyer. This agent does not want to batch, but they've introduced me to the property. I would like to give them a referral commission. Then I just give them an ordinary 20% referral commission, because then it is the seller's decision. Is he going to accept it, yes or no? And then you inform them, listen, you did not want to batch, you do not have a sole and exclusive mandate, but however, I will give you a referral. And normally they don't fight you. But if you don't give them anything, they can turn around and they can claim commission from the seller maybe, and the seller will then be liable for a double commission.
Thank you.
Any questions? The estate agent can also negotiate an option on behalf of the purchaser as long as there is no option fees involved. So meaning that maybe they just want to get their finance in order for a week or two, or the wife must still come. There can be options why they want an option. In terms of an open mandate, the client remains entitled to sell the property himself or through another estate agent. I'm not going to read the whole thing. We are close to 7 o'clock. We've already done this open mandate, sell mandate, sell and exclusive mandate. The nature of remuneration repayable to the estate agent is very important that the estate agent discuss the payment of commission with his or her client at the outset of their relationship. The issues that need to be communicated and agreed on are the liability to pay commission, the amount, and the due date of payment. The commission is payable by the mandator unless the parties agree otherwise. The amount of remuneration that is payable once the agent has fulfilled the mandate is negotiable and agreed on by the parties. This amount is earned as soon as the mandate has been fulfilled by the estate agent. The date of payment is agreed by the parties, and that's normally on the date of registration. Okay, it's important to note that the agreement must be binding. Example, if it is subject to any suspensive condition, it only becomes binding once the conditions have been met. No commission is payable if the contract is voidable and it is duly set aside. So this is now, we come to the end of this module. My suggestion is the following. I would like, because we are scheduled to do, this is now module 2, to do module 3, because there are 6 modules. My suggestion is let's finish all the modules first, and then it will give me time for preparation for our rental agreement, and to pull in the acts and to do a proper slideshow. And we can then on one session just do that, but at the end of the time. Do you all agree to that? Because I think if we do it tomorrow night, it's going to shuffle the schedule a little bit. Kabelo, Nomisa, how do you feel about it?
That works, Rina.
Yeah, I think so. Let's do it, because I really would like to spend lots of time on it and good time on it. Maybe we can get an attorney in as well to help us on that one, or another specialist. But I think it's a very good option, topic. But I would like to spend proper time on that. And I think for one night, it's short notice. I would prefer if we can finish our slides first. Any other questions?
Yes, Rina, just a question. Apologies, unfortunately, last week I missed that 2 classes and the previous week. In terms of the materials on LMS, are they fully updated? Because this presentation that I'm looking at, I think I didn't see it when I was looking at the LMS.
On LMS, everything is there. All the activities, where am I now? It is up to, all the modules are there where the activities are on LMS.
Right, so this specific one that we are dealing today, is it under legislation or practice?
It's under, Kabelo, now you ask me first. Let me quickly tell you. Let me just open this one document. Okay, learner unit number 3, it is market, sell and lease a property. That's marketing. That is the first one. Now we've done the second one, that's sales marketing of real estate. So tomorrow night we're going to do the business principle in real estate. There are 6. Yes.
Sorry, just to be with Kabelo here, I'm on LMS as we speak, and it should be under real estate practice. I see more modules are uploaded there. Module 4, 5, 6, and 1. I don't see number 2 on the module 2.
I've done module 2. Then something went wrong with module 2 because I've done all the activities. Is the activities?
I'm not seeing module 2 and 3, and the activities are there. it says activity module 1, 2, 3, 4, 5, 6. But
Okay.
on the learning units, we missing module 3 and 2, or well, I'm missing module 2 and 3.
Okay, because I've done it first and then I've done the activity. So let me, just after the class, I will do it. I will check it immediately. Thank you.
All right, thank you. Cheers.
Yeah, I'll quickly go and have a look. Thanks, Delon. Any other questions? Okay, then we will then adjourn the class for tonight, and we will look forward for tomorrow night. So it's business principles tomorrow night. And thank you for tonight, and have a blessed evening if there's no other questions.
Thank you, Rina.
Thank you. Bye-bye.
Thank you. Bye.
Bye-bye.
Thank you, Rina. Bye.
Namisa? Namisa?